The day they let me go, my boss didn't even have the decency to do it in person. I was sitting at my desk, same desk I'd sat at for 19 years, when my phone buzzed with a calendar invite. Quick sync with legal and HR. No subject line, no agenda. Just a 30-minute block dropped on my calendar with 12 minutes notice, and the little conference room on the 4th floor that everyone at the company called the departure lounge because nobody ever walked out of it with their badge still working. I was 54 years old, senior director of financial systems at a mid-sized logistics company out of Columbus, Ohio. I'd joined when the company had 200 employees and a spreadsheet for an accounting system. By the time they walked me into that room, we had over 4,000 people across 11 states and a financial infrastructure that I had personally built, patch by patch, crisis by crisis, across nearly 2 decades. I knew every line of every process. I knew where the bodies were buried, not the shady kind, just the kind that accumulates in any company that grows too fast. The workarounds, the legacy integrations, the 6 a.m. calls I took when the quarterly close broke. The 3 times I'd rebuilt the entire reporting system from scratch because the CFO changed and the new one wanted a different format. The man sitting across from me in that room was not someone I recognized at first. Mid-30s. Expensive haircut. He introduced himself as the new VP of Finance Transformation. He'd been brought in 4 months earlier from a consulting firm in Chicago. I had met him exactly twice. He slid a folder across the table without making eye contact. "We're restructuring the finance systems function," he said. "Your role is being eliminated effective today." That was it. 19 years. Effective today. The HR woman, I didn't know her name, she was new too, handed me a separation agreement and told me I had 21 days to review it. She said I could keep my laptop until Friday to retrieve personal files, but that my system access would be revoked within the hour. She said they appreciated my contributions. She said it the way you'd read it off a card. I didn't say anything. I signed for the box of desk items they'd already packed. I walked to the elevator. I pressed the button for the parking garage. And somewhere between the 4th floor and the basement, something shifted in my chest. Not grief exactly, and not rage. Something quieter than both. Something that felt like the moment before a storm when the air goes completely still. My wife Carol was in the kitchen when I got home. It was 2:30 in the afternoon on a Tuesday. She took one look at my face and turned off the stove. What happened? I set the box on the kitchen table. The picture of our son at his college graduation. The coffee mug he'd given me that said, "World's okayest dad." A small succulent she had given me 3 Christmases ago that I had somehow kept alive at my desk all that time. "They let me go," I said. She didn't say anything for a moment. Then she came around the island and put her hands on either side of my face. "Okay," she said. "Okay, we'll figure it out." I loved her for that. For not asking how or why or what we were going to do about the mortgage. For just being there, solid and real, while the ground was still shaking under me. Later that night, when she was asleep, I sat at the kitchen table with a glass of water and the separation agreement in front of me. It was 14 pages. I read every word. There was a clause buried on page 9, a non-solicitation agreement, meaning I couldn't recruit any current employees to a new venture for 24 months. There was also a clause stating that any financial systems, methodologies, or process documentation I had created in the course of employment were the company's intellectual property. I read that last part 3 times. In the course of employment, I set the agreement down. I went upstairs and opened the closet in our home office. The one Carol used to threaten to organize but never did, which meant it was exactly the way I'd left it. I pulled down a plastic bin from the top shelf. Inside were old notebooks, hard drives, printed reports in labeled folders. I'd been meticulous my whole career, kept copies of everything, not for any reason I could have articulated then, just habit. just the way my father had taught me to keep records of everything important, the same way he kept receipts in a shoebox under his bed. I carried the bin to the kitchen table and started going through it. The first notebook was from 2009. I opened it and found, in my own handwriting, the original architecture diagram for the automated reconciliation system I had designed. The one that the company's entire monthly close process ran on. The one that the new VP of Finance Transformation had, in his first week, called one of the most sophisticated in-house systems I've ever seen in a company this size. The date on the notebook was March 14, 2009. I had designed that system before I was employed there. I need to back up and explain something because this matters. In the spring of 2009, I was a freelance consultant. I had been doing contract financial systems work for about 18 months after leaving a corporate role I'd grown out of. One of my clients during that period was the company. Back then, it was a small regional freight company with maybe 60 employees and a CFO who kept 2 sets of books in QuickBooks. I spent 4 months building them a reconciliation system as a contractor. I charged by the hour. I used my own tools, my own frameworks, my own design logic that I had developed over years. When the engagement ended, they liked the work so much they offered me a full-time role. I took it. The employment agreement I signed had a standard IP clause. At the time, I'd read it the way most people read those things, quickly, trusting that it was boilerplate. What it said technically was that anything I created in connection with my employment belonged to the company. What it didn't say, what most of those agreements assume without stating, was that it applied to work I had created before I was an employee. The reconciliation system I had built as a contractor had been the seed of everything that followed. Over 19 years, I'd expanded it, rebuilt it twice, layered integrations on top of it, but the original architecture, the logic, the framework, the design was mine. Created on my own time, with my own tools, before I had signed anything. I hadn't thought about this in years. Why would I? I wasn't planning to sue anyone. I wasn't planning anything, but sitting at that kitchen table at 1 in the morning, reading a separation agreement that claimed everything I had built as theirs, something woke up in me. I didn't sign the agreement that night. I put it back in the folder, put the folder in a drawer, and went to bed. The next morning, I called my brother-in-law, Todd. He wasn't a lawyer, but he was married to one. His wife, Claire, practiced employment law out of a small firm in Cincinnati. She'd never taken a case of mine before. There'd never been a reason, but I trusted her completely. I drove to Cincinnati that Thursday. Claire met me in her office, which was neat and spare and smelled like coffee and old paper. She was the kind of person who never wasted a word, which I appreciated. I laid everything out on her conference table. The separation agreement, the old notebooks, the contractor invoices from 2009, the design documents with dates. She didn't say anything for a long time. She put on her reading glasses and went through the documents one by one, slowly. "Do you have the original contractor agreement?" she asked finally. "I think so. I'd found it in the bin the night before. A 2-page letter agreement on the company's old letterhead, back when they had different letterhead, signed by me and their original CFO, who'd retired years ago. It specified the scope of the work, the hourly rate, and this was the part Claire pointed to with her pen, a clause stating that any deliverables produced during the engagement remained my intellectual property until full payment was received and a formal IP transfer was executed. "Was a formal IP transfer ever executed?" she asked. I thought about it. "Not that I know of. I don't think we even talked about it. I just started full-time." Claire took off her glasses and set them on the table. "Then they may not own what they think they own," she said. "And the clause in your separation agreement, the one claiming everything you built in the course of employment, may not cover work that predates your employment and was never formally transferred." She told me not to sign anything yet. She told me to go home and find every piece of documentation I could from that contractor period. Invoices, emails, design files, anything with a timestamp. I spent the next 2 weeks doing exactly that. I went through the old hard drives in the bin. I found the original project folder still intact, still dated. I found 11 emails from the CFO at the time, praising the system design, asking questions about implementation, referring to it as your framework. I found a final invoice I had submitted in May 2009 with a line item that said Reconciliation System Architecture, Final Deliverable. I found, buried in an old email thread, a message from the CFO that said, "Great work on the system. Let's talk about bringing you on full-time." No mention of a transfer of intellectual property, no formal handoff, just a job offer. I also spent those 2 weeks doing something else. I had built the financial systems at that company. I knew them inside and out. I knew that if the reconciliation system were ever to be updated or challenged or audited, there was one person who could navigate it: me. Because I was the only one who truly understood it at its foundation. The new VP of Finance Transformation didn't know that yet. He thought he'd eliminated a redundancy. He thought the system ran itself. It didn't. About 6 weeks after I left, I got a call from a former colleague, someone in accounts payable who I'd mentored for years. She told me carefully that there had been a significant issue with the quarterly close. Something in the reconciliation system had thrown an error that nobody could diagnose. They'd brought in an outside consultant at considerable expense. The consultant had spent 2 weeks on it and solved only part of the problem. "They keep saying they need someone who knows the system from the ground up," she said. "Nobody here does." "I know," I said. I thanked her and wished her well and didn't say anything else. Meanwhile, Claire had been working. She sent a letter to the company's legal department, not threatening, not accusatory, just informational. It stated that she was representing me in reviewing the separation agreement. It noted that certain IP claims in the agreement might be worth discussing before I signed. It asked for a meeting. The response came back quickly. Their outside counsel called Claire within 48 hours. Apparently, the letter had caused some alarm. There were 3 months of back and forth. I won't detail all of it because, frankly, some of it was tedious, the kind of tedium that legal negotiations require, where you say the same things in slightly different ways until both sides are exhausted and ready to find a resolution. But the substance of it was this. Claire's position was that the core architecture of the reconciliation system, created during my contractor engagement in 2009, had never been formally transferred to the company. That made it, legally, still mine. And since the company's entire financial operations ran on a system that was built on that architecture, a system that was now struggling without my presence, they had a problem. Their position was that employment and the course of work over 19 years had effectively transferred ownership through conduct, even without a formal agreement. This is where it got interesting. Claire filed for a preliminary ruling. A judge in Columbus reviewed the contractor agreement, the employment agreement, the documentation I had assembled, and the absence of any formal IP transfer. She issued a preliminary finding that the question of ownership was legitimate and required full adjudication. That was enough. The company's new CFO, not the one who hired me, a different one, the third one since my tenure began, called Claire directly. He wanted to settle. The settlement took another 6 weeks to negotiate. Carol sat across from me at our kitchen table every night during that period, drinking tea and reading, being present without hovering. Our son called from Seattle every Sunday. He didn't know all the details, but he knew enough. "You doing okay, Dad?" "Yeah," I told him. "Getting there." The terms of the settlement are confidential, which means I can't tell you the number. What I can tell you is that it was significant, enough to retire on, if I chose to. Enough to make the 19 years feel, finally, like they had been properly accounted for. But there was something else in the settlement that mattered more to me than the money. They had to formally acknowledge in writing that the original reconciliation system architecture was my intellectual property, and they had to license it from me, pay me on an ongoing basis to continue using it. The VP of Finance Transformation, who had handed me that box of desk items with 12 minutes' notice, was gone by the time the settlement was signed. I heard through the grapevine that the quarterly close issues had continued, that his tenure had been turbulent, that the board had grown frustrated. I didn't know the specifics and I didn't try to find out. I want to be honest about something, because the people who know this story sometimes frame it as a revenge story, and I'm not sure that's right. I didn't set out to destroy anything. I didn't build a competing company. I didn't leak anything to the press. I didn't make a single phone call to a board member or a journalist or anyone else with the intention of causing damage. I just stopped being passive. I stopped assuming that institutions would be fair if I was loyal. I started looking at what I actually had and what it was actually worth. The notebook with the March 2009 date had been sitting in that closet for 15 years. If they had treated me differently, if the man who handed me that box had looked me in the eye, if someone had said thank you and meant it, I probably would have signed the separation agreement on day one and moved on with my life. I'm not a vindictive person. I'm a methodical person. There's a difference. What they didn't understand when they decided I was redundant was that they were the ones who needed me. Not because I was irreplaceable as a person, nobody is, but because they had been operating on a foundation that was mine without ever stopping to understand it. They had mistaken my silence for smallness. Carol and I went to the coast that fall. We rented a house on the Oregon coast for 2 weeks. Something we'd talked about for years and never done. I spent a lot of time walking on the beach in the mornings, which is something I had never been a person who did, and found that I liked it more than I expected. The ocean doesn't particularly care what you built or who took credit for it. It just keeps going. Our son flew out for the last 4 days. We ate crab and played cards and watched old movies. He still didn't know all the details. I told him a version that was true without being exhaustive, that I'd had a dispute with the company, that it had been resolved, that we were okay. More than okay? He asked. Yeah, I said, more than okay. I'm not retired. I took 6 months before I started consulting again, independently, on my own terms. I have 3 clients now. I work from home most days. I set my own hours. When a client asks me to do something that doesn't make sense, I say so, and they either listen or they find someone else, and I'm fine either way. The succulent from my desk is on the windowsill above the kitchen sink now. Carol repotted it in something nicer. It looks better than it ever did at the office. Last spring I got an email through my consulting website from a young finance analyst. Couldn't have been more than 26. She said she was trying to understand automated reconciliation systems, and someone had pointed her toward a methodology paper I had published years ago, back when I still bothered publishing. She wanted to know if I'd be willing to talk through some of the core concepts. I wrote her back the same day. We scheduled a call for the following Tuesday. She was sharp. She asked good questions. She had that particular kind of hunger that reminded me of myself at her age, before the years of meetings and quarterly closes had taught me to keep my head down. We talked for almost 2 hours. When we were wrapping up, she said, "Can I ask, did you build all of this yourself, like, originally?" "Yeah," I said. "I did. How long ago?" "First version, about 15 years. She was quiet for a moment. "And it's still running?" "Last I heard," I said. "Yeah, still running." I didn't elaborate. I didn't tell her the rest of it. Some things you don't need to explain to be understood. I keep thinking about that plastic bin in the closet. 15 years it sat there. Carol threatened to organize it every spring and never did, and I never pushed her to, for no reason I could have named at the time. Just inertia. Just the way things accumulate when you're busy living your life. But that bin was the whole case. Without it, I would have signed the separation agreement on day one, taken whatever they offered, and spent the next few years quietly resenting a decision I'd accepted without a fight. The documents were always there. The truth was always there. What changed wasn't the facts. It was whether I was willing to look at them clearly and do something about it. I think about that a lot now. There's a version of this story where I'm the victim, where a company discarded a loyal employee after 19 years and got away with it because I was too tired or too defeated to push back. That version is easy to tell. It's also incomplete. Because the other half of it is that I had built something genuinely valuable. I knew it was valuable. I had the records to prove it. And for a long time, I had made myself small enough that I never had to reckon with what that meant. Integrity, I've come to believe, isn't just about how you treat other people. It's also about how honest you're willing to be about your own worth, about what you've actually built, about what belongs to you, not in a grasping way, but in a clear-eyed, accurate way. I had let a company claim ownership of something that was mine because I hadn't wanted to be difficult. I hadn't wanted to be the kind of person who made a fuss. 19 years of not making a fuss, and in the end, they handed me a box with 12 minutes notice. What got me through wasn't anger. Anger burns fast and leaves you empty. What got me through was something slower and colder and more useful. The willingness to sit at a kitchen table at 1 in the morning and read every word of a 14-page document, and then drive to Cincinnati, and then spend 2 weeks going through old hard drives, and then wait, month after month, while the legal process moved at its own pace. Patience is underrated as a form of strength. So is the ability to keep your mouth shut when keeping it shut serves you better than anything you could say. And Claire, I think about what she represented. Not just legal expertise, but the reminder that you don't have to fight alone and that asking for help isn't a concession, it's intelligence. She saw the case clearly because she wasn't emotionally tangled in it the way I was. That distance was worth more than any amount of outrage I could have brought into that room. The young analyst I spoke with last spring, the one who asked if I'd built the system myself, she reminded me of something I'd forgotten. There's a kind of work that outlasts the circumstances that produced it. If you build something real, something grounded in genuine thought and honest effort, it persists. It runs. It keeps running even when the people who underestimated you are long gone. That's not a guarantee of justice. The world doesn't promise you that. But it is a reason to build carefully, to document honestly, and to never let someone else's dismissal become your own. The succulent is still on the windowsill, still alive,